Hello, thank you for joining us today. Welcome to today's webinar. My name is Agnes Kolbeck. I am an associate in Thompson Hine's Employee Benefits and Executive Compensation Practice in our Washington, D.C. office. I am joined today by several colleagues, Meredith Reeves and Nate Ingraham. Both are associates in our Washington, D.C. office. In addition, we have Brian Lamb, a litigation partner in our Cleveland office, and Tim McDonald, a partner from our Atlanta office. 2025 has already brought major developments in the evolving landscape of ERISA litigation. Today, we will discuss the latest decisions and emerging trends that are shaping fiduciary risk for the remainder of the year. Before we begin, a few housekeeping items. Today's program is being recorded, and we will send the recording and slides to all attendees in a few days. If you have questions during the webinar, please use the question box located in the control panel on the upper right of your screen. We will answer as many questions as we can at the end of the webinar. CLE credit for today's webinar is pending. Please be sure to complete the verification of attendance survey. The link is posted in the chat box. I will announce the tracking code at the end of the webinar. And now Nate will begin our presentation.
Thank you, Agnes, and thanks everyone for joining us today. We are really excited to cover key developments in ERISA litigation from the first half of 2025. It has been a whirlwind year already, and we're not even midway through the year technically. We have had a Supreme Court decision come out, plenty of new case filings, and some interesting trends emerging. So there's a lot for us to discuss. We've structured today's session to cover a variety of topics. So no matter what your particular area of interest, we've got you covered. Next slide, please. So here's a quick look at our agenda. We are going to start today's presentation by sharing some recent data that we've compiled on ERISA class action filings. After that, we're going to cover the Supreme Court's ruling in Cunningham v. Cornell. That's a decision that has been getting plenty of attention. After that, we're going to spend some time highlighting some recent trends in 401k fee litigation. Next, we'll pivot and talk about the duty of loyalty. That's a topic that's become a real focal point lately. And then finally, we're going to wrap up by covering some emerging trends in health and welfare plan litigation. So let's dive right in. So we're going to start by taking a quick snapshot of ERISA class action litigation so far in 2025. So focusing on the time period of January 1 to May 30th, which was last Friday. And we're focusing specifically on class actions here. So ERISA litigation definitely casts a wider net than just class action lawsuits, but the class action suits often present the biggest challenges. So as of last Friday, we've tracked 53 class actions. And for context, that's certainly on the higher end historically, for this point of the year, that is. We've seen robust activity both on the retirement side and then also on the health and welfare side. And keep in mind that this slide is only counting new filings. So it doesn't account for the whole wave of cases that are making their way through the courts, at various stages of litigation. Cases take sometimes years to resolve. Next slide, please. So to build on that point, let's look more closely at the data that we've compiled. So looking at this slide here as a whole, what this slide is actually showing is that a lot of the class action activity year to date is being driven by newer or emerging theories. And what I mean by that is claims that we've only started seeing in significant numbers over the last few years, and now they're a full-blown wave. So on the retirement side, we have seen year to date 21 new cases challenging the use of forfeitures in 401k plans. We're going to go over those in a bit more detail later in the presentation, but essentially these cases challenge how plans handle and treat forfeited unvested contributions. Investment performance is also a big category. This has been around for as long as I can remember, and as long as class action lawsuits have been going on in this area. So it's not a new area, but it shows that it's an area of strong momentum. Plaintiffs are continuing to challenge investments such as target date funds, stable value products, and then proprietary investments as well. On the health and welfare side, leading the charge is this continued surge of litigation challenging plans that impose tobacco premium surcharges and how those surcharges are structured. These claims have actually been around for a number of years, but it's only in the past couple of years that they've been filed en masse across the country. And then finally, the last category, record keeping fees and share class claims. These are more like traditional excessive fee 401k lawsuits, and these continue to be filed. There's no signs of slowing down. 2024 saw a lot of these cases being filed, so a lot of them are working their way through the courts. But it is interesting just to see that year to date in 2025, some of these other claims are stepping into the spotlight. Next slide, please. So with that overview of filings year to date, I'm now going to turn things over to my colleague, Tim McDonald, who's going to walk us through Cunningham v. Cornell and what it means for prohibited transaction litigation.
Thank you, Nate. Cunningham versus Cornell was an important ruling in ERISA litigation. Admittedly, for most on the call, it was disappointing for those who represent plans, fiduciaries, and plan sponsors. But the Supreme Court taketh away and the Supreme Court giveth. And at the end, they threw an intriguing possibility that's not been used in ERISA litigation before. I don't mean to make it sound like exactly a high wire act, but there is a potential workaround for this problem. It's probably going to take a year to two to see if the courts will be receptive to it. But having the Supreme Court at least give a light imprimatur of it may give some wind in the sails of defense lawyers, and I'll get to that in a minute. Believe it or not, this exciting Supreme Court decision begins with the inner workings and interplay of ERISA's prohibited transaction sections. Many of you are familiar with these wonderful sections, 1106 and 1108. I'm not going to go into them in detail here. The key portions as it relates to the Cornell case are on this slide. Generally, this statute in 1106 has an extremely broad prohibition against seemingly every type of agreement that the plan would need just to function. Then in section 1108, there's a long list of exceptions, some which relate to investments and some which specifically permit the contracting for services necessary for the operation of the plan. That's where your normal record-keeping agreement, like the two that were at issue in Cornell, come into play. Congress could have reversed that and simply prohibited certain actions and left everything else as fair game. But remember, this is a statute that arose out of a tremendous number of pension failures in the 50s, 60s, and 70s. And so Congress wrote this with the idea of cabining or limiting the ability of those who control the plan assets to act. That policy choice actually turns out to be an underlying factor in the decision in Cunningham. Next slide, please. So looking at this case, Cornell had hired Tia Kreff and Fidelity to act as record keepers for two different defined contribution plans. The plaintiffs allege that a reasonable per head participant fee for these participants would have been $35 a year. They also allege that the Cornell plans were levying charges of between $115 and $200 a year. And these plans had a combined $3.34 billion in assets. So these are not plans that were lacking for bargaining power, which was a mainstay of the early sections in the complaint filed by the participants. As it relates to record keeping, there were two types of claims in this case. Fiduciary breach claims, those you're probably already very familiar with, that the committee did not act prudently in trying to keep these fees in check. At the same time, there was a parallel claim that these fees, because they were unreasonable, were a prohibited transaction. And although the plaintiffs, the participants, could not recover twice, in other words, they were either going to win on one, the other, or both, but get the same amount of money either way. But as it turns out, the way this case progressed, the fact that they pled both of them became a lifeline and gives them a second chance because they actually lost the fiduciary breach claims the first time around. Next slide, please. So the lower court decisions. A key fact here for those that are not litigators, you really have three different points of inflection in litigation. A motion to dismiss, where you're just testing whether or not the complaint is strong enough to go on to discovery. Then a motion for summary judgment after millions of dollars of discovery in a case like this have taken place. And then if summary judgment doesn't resolve it, trial. It is really important for plan sponsors, fiduciaries, and administrators to be able to have a credible motion to dismiss up front to avoid the expense of discovery in the second phase of the case. And so in this instance, the structure of the prohibited transaction provisions comes into play. The trial court and the Court of Appeals held that the plaintiffs, the participants, had to not only plead that there was an agreement, but also that the fees were unreasonable. And that unreasonableness, again, comes from 1108, which is the section that's the exception to 1106. Now, Cornell prevailed at the motion to dismiss stage on these prohibited transaction claims, so they never got to discovery on those. They got to discovery on the fiduciary claims and actually were able to show that Cornell had acted imprudently but could not show loss because their two experts could not show comparable plans or convince the court that they had a methodology that the plans they were using were comparable. So they lose on the fiduciary breach claims after discovery. They had already lost on the prohibited transaction claims before discovery. And the case as it goes to the Supreme Court was basically to allow the participants to come back and go through discovery again on the prohibited transaction claims. Next slide, please. At oral argument, it did appear that there was a division among the court, but once you got to the decision, it was a 9-0 decision with a concurrence by Justice Alito that really didn't add anything to the law, but just bemoans the state of things like plans, committee members, and sponsors would after reading this decision. It held it because the exemptions were an affirmative defense. In other words, it was Cornell's burden to show that the fees were reasonable. All that the plaintiffs had to plead was that there was a record-keeping agreement. Full stop. Easy peasy. They're going to get that claim by a motion to dismiss and to discovery almost every time. Now, the Supreme Court tried to throw some bomb out there for the plans and the administrators and say, look, there are things that might make this not that bad. Next slide, please. They say, for example, you can challenge standing, you can seek Rule 11 sanctions if the claim is weak, you can cost shift under ERISA, and although not listed here, they also said, you know, judges can limit discovery in certain ways to make them less expensive. Well, all of these things have already been around, and they haven't worked so far, so it was not a lot of help. What's intriguing is Rule 7 of the Federal Rules of Civil Procedure. They point to this rarely used procedure that would allow the plans to force the participants to plead reasonableness immediately as opposed to getting into discovery. All of the cases that use that I've been able to find actually arise out of civil rights cases. None are ERISA cases at all, so they're plucking this idea from governmental immunity cases where the government has immunity as a defense to make the participants plead it as an affirmative part of their case. And by analogy, they're suggesting the plans do that here. Next slide, please. So other than this possible solution, this is largely a hands-down win for participants. They're going to get to discovery, even if they can on a fiduciary breach claim, on a prohibited transaction claim in almost every case. That gives them more leverage to force settlement. And obviously, the converse happens for the defendants. there's more pressure on them to settle because of the impending cost of discovery. Next slide, please. So the takeaway here is, unfortunately, this is not one that you can do anything day to day to prevent this or to set up a better defense other than what you're already doing in terms of best practices for fiduciaries. This is really something where the changes in the litigation strategy if you're unfortunately the target of one of these lawsuits. But that doesn't mean that it's not just as important as always to follow those good fiduciary hygiene steps so that if you do have one of these cases, being able to use Rule 7 is a viable alternative for your lawyers. Thanks, Nate.
Excellent. Thank you, Tim. So I'm now going to talk more about I'm kind of revisiting 401k fee litigation and talk about what the state of play right now is generally. Next slide, please. So as I alluded to earlier, excessive fee lawsuits, and these are lawsuits challenging the fees incurred in a plan or the performance of the investments in a plan, but they're generally referred to as fee cases, even though some don't involve fees by way of background. But these cases keep coming, particularly as I spotlighted, these claims focusing on underperformance have been very pronounced in the first part of this year. But what we have noticed is a trend in terms of these cases evolving. And the plaintiffs' lawyers in ERISA is obviously a notoriously complex statute. The plaintiffs' lawyers who make their living litigating in this area are generally very creative and sophisticated, and they have continually refined the theories that they put forth in their complaints. And so one thing that we're seeing right now is that these traditional excessive fee claims, such as claims challenging record-keeping fees or share class claims, meaning the share classes of different mutual funds included in the plans, those claims are paired with other claims, such as the alleged misuse of the forfeitures in the plan. And so in this landscape, we are increasingly seeing both pled, and it's really does create challenges because a plan sponsor facing one of these suits really does have to navigate different angles of the suit. And to Tim's point, going back to Cunningham, there is an expectation about, I should step back and say, historically, a lot of these claims are pled as breaches of the fiduciary duty of prudence under ERISA 1104A and duty of loyalty as well. And so there's an expectation that given that the pleading standard has been lessened for prohibited transaction claims, that the excessive fee cases will further evolve in that these prohibited transaction claims, which the Supreme Court has ruled on in Cunningham, will be paired with prudence claims, potentially creating another challenge for employers facing these lawsuits. Although, as Tim talked about, the Supreme Court highlighted some potential roadmap to navigate that. And going to this next point about the pleading standards. And so although the Supreme Court in Cunningham issued a ruling on prohibited transaction claims, the pleading standards for the fiduciary duty of prudence in particular are still very unsettled. As you may recall, it feels like a lifetime ago now, but in 2022, the Supreme Court decided the Hughes v. Northwestern decision, and it was a very short opinion. The court did not offer any robust guidance on the pleading standards under the duty of prudence. And so what's happened as a result of that, and to date, is essentially that the law in these cases has developed inconsistently depending on which judicial circuit you're in, and different standards are applied depending on where the case ends up being filed. And ERISA has a pretty permissive provisions to allow cases to be filed all over. So that also creates additional challenges. But one piece of potential good news is that the Supreme Court does seem to be aware of this current uncertainty. And in a few recent cases on hot button issues, one of which was this requirement in some circuits to have a meaningful benchmark, which is essentially in cases challenging underperformance or fees, plaintiffs have to put forth sufficient detail to compare the investment that the plaintiffs are challenging. And so the Supreme Court has ordered a response to a petition on a case in the Sixth Circuit that addresses that very issue. And then there's a related briefing going on in the 11th Circuit on the issue of causation, which is a separate issue. But all of that is to say that the Supreme Court does seem to be aware that the current environment is difficult and unsettled, and so things could and may evolve as we go forward. In the meantime, we really are seeing a range of outcomes in excessive fee cases, and so it's some cases will be dismissed at the pleading stage, at the motion to dismiss stage. Some will not, and as Tim talked about, that's kind of a critical turning point in the case, because after a motion to dismiss, the costs in a case go way up, and there's accompanying pressure on the parties. So we are seeing regular settlements in these cases, but we've also seen many plan sponsors take cases to trial over the past couple of years. In particularly, I've noticed over the past 3 or so years, there's been a number of these trials, and in most of the trials that have taken place, the employer has prevailed at trial. So that shows that there is some oomph to an appetite to fight these cases. Although, of course, once you get to trial, you've already incurred significant costs and time as well. So there's downsides there which kind of begs the need for more concrete guidance. So the last bullet I have here is just kind of a standard recommendation to continue following fiduciary process, and that's like, as ERISA attorneys, that's really our MO. So we're going to say that every time we do this. But it is true in that although the pleading standards at the motion to dismiss stage are unsettled, there are a number of robust judicial opinions out there, some of which have stemmed from these trial wins that lay out a clear roadmap for committees and other fiduciaries to follow in reviewing plan expenses and investments. And so there's certainly hope. Next slide, please. So now I want to zoom in on the forfeiture litigation that I've mentioned kind of repeatedly throughout my segment. So forfeitures, as background, occur when the participant leaves the plan before they're fully vested in funds in their account. And so these unvested contributions will then go back to the plan as forfeitures. And so then the plans will typically use these forfeitures in one of three ways: either to offset future employer contributions, pay down plan expenses, or reallocate the funds, the remaining funds to participants. And so under guidance issued by the IRS, all those options are permissible, so long as what the plan does is consistent with the terms of the plan, which is a key fact. But so despite this kind of long-standing guidance from the IRS, they've in the past few years have proposed proposed regulations to clarify that, but that kind of treatment goes back longer than that. But still, there's been widespread challenges to the allocation of forfeitures and plans. Next slide, please. So back in, I think it was October 2023 or around that time frame, certainly late October, a few of these initial lawsuits were filed in California against California-based companies. And the reason that, a contributing reason for that is because several of these lawsuits were filed by one firm that was based in California. But since that initial, and so a lot of the case law that we've seen to date, because the development of case law on this issue kind of lags behind. Serving as an aside, I served as a law clerk, and I remember the ERISA cases would sometimes take longer than others to decide, just because the issues are a little thorny, especially for someone straight out of law school. So that was my own personal experience. But so the claim in these forfeiture cases is that plan sponsors should have used the forfeitures in a certain way. So that the plaintiffs are alleging in the complaints that they should have used the discretion under the plan document to pay administrative expenses instead of using them to reduce employer contributions. And the basic theory of harm is that as a result of this, the plan sponsor benefited at the expense of plan participants. Next slide. So the framework for these cases that I just explained falls into this first category, alleging that there was discretion under the plan, and there's really no question in the cases that the plan language was followed, but plaintiffs are basically saying that using forfeitures in this way to reduce future employer contributions is per se breach of fiduciary duty and prohibited transaction. In other cases, especially some more recent filings, plaintiffs have taken somewhat of a different approach in claiming that the practices were inconsistent with the terms of what the plan says. So that's more of that includes an additional plan interpretation issue that needs to be resolved. Next slide, please. So here's the current scorecard. We've counted 7 motions to dismiss that have been granted in these cases, 2 of which have been dismissed with prejudice, and so the others have plaintiffs have been given opportunities to try again to amend their complaints. There is some momentum in dismissing these complaints, particularly the theory that there's no issue that the plan followed its language, and it's just a discretionary question. And so last week, another court in California granted a motion to dismiss, and notably that court relied on a ruling that has been, or a few rulings that have in California that have been cited in these dismissals. And so we are seeing traction for employers in fighting back these claims. But as I've mentioned, I mean, it really does, some of the outcomes on motions to dismiss at least will depend on on the preferences of the judge and the predilections of the judge. And so other cases have survived motions to dismiss. We've seen one case that has reached a preliminary settlement. So there have been a mix of early outcomes at this point in the litigation. Next slide, please. So there's no rulings at the Court of Appeals yet. There is a case in the Ninth Circuit, which includes California, that we're briefing on an appeal where the claim was dismissed is pending. So we should see some initial appellate precedent over the next several months. The law's still unsettled, but at this point, the single most important recommendation we could make is to just make sure you're reviewing how the plan addresses forfeitures, make sure it matches your current practices, and then also review the Form 5500s as well, and make sure that there's see how those line up and if there's any tension. Notably, like if there is an issue with the Form 5500, it's not necessarily a deal breaker. There's recent case law to the effect that it's not Form 5500. It's not a plan document. It's not binding, but it will trigger scrutiny from the plaintiff's attorneys who are reviewing these closely. And then finally, just wanted to note that some courts, even in opinions dismissing these claims, have come to the conclusion that decisions related to the allocation of forfeitures are fiduciary decisions. And so with that case law out there that that plaintiffs can cite, it's definitely recommended to review these forfeitures on an ongoing basis and continue to monitor developments as they unfold. Next slide, please. So, so here we have, there are a couple slides addressing the recent challenges to stable value products. So these funds are, recognized for protecting against market downturns, providing steady returns. There have been several recent cases, noticeable uptick in 2025 and in 2024 as well, challenging these funds and plans. And essentially what has been alleged is that there were other comparable products that were available, other stable value funds or money market funds that were available that would have provided higher rates of return, and that participants missed out. These are just some of the cases, and there's others as well in the target date fund area where plaintiffs essentially challenge investments as being too conservative. And so these cases illustrate that trend. Next slide, please. There is established case law on these underperformance claims because this has been litigated for a long time. And so I mentioned the requirement in some circuits for there to be a meaningful benchmark. And so in motions to dismiss on these cases, employers have pointed to that established case law, although it's not universal across the United States at this point. And then also there's a lot of case law, showing that plaintiffs have to demonstrate in their complaints sufficient underperformance for there to be inference that there's any breach of fiduciary duties. And so essentially that's the landscape going on right now. In the interest of time, I'm going to wrap up my segment, but just note that these slides will be disseminated following the presentation. So feel free to reach out if you have any thoughts or questions. And with that, I'm going to turn it over to my colleague, Brian Lamb, who's going to cover recent developments in the ERISA's duty of loyalty.
Thanks, Nate. I'm going to focus in on what I think is the most interesting trend to me as a litigator of what is going on in ERISA litigation from a trend perspective. For the past couple decades, we've really been focused on defending duty of prudence claims, and the plaintiffs' lawyers are very focused on prudence claims. And what we've seen is that corporate America has really stepped up its game in terms of running organized fiduciary committees and running prudent processes, having regular meetings, keeping minutes, hiring good experts, monitoring things, swapping out poorly performing investments, all the process stuff that goes into prudence. I mean, there have always been loyalty claims and prohibited transaction claims alongside those, but really for the past 20 years, I would say the plaintiff's bar has been focused on prudence. Over the last couple years, particularly the last 12 months, I've really seen the plaintiff's lawyers putting an increased emphasis on the duty of loyalty. And there's a reason for that. Partly, I think we're all getting better from a prudence perspective. The cases are getting harder for the plaintiffs to win. But more importantly, the duty of loyalty is the highest duty known to law. judges hate fiduciaries who act for their own self-interest at the expense of other people's money, other people whose money they're supposed to be protecting. So we have seen a couple of really high-profile duty of loyalty cases in the past 12 months, and I feel like we're seeing questions in depositions being asked by the plaintiff's bar that lead me to think that this is an organized effort on their part, starting with a prudence case, asking questions designed to figure out if there's loyalty problems. For example, asking fiduciary committee members, did you ever accept any tickets to a ball game from one of your big vendors to the plan? When the answer is, well, actually, I have been to a couple ball games with vendor X, it opens a whole Pandora's box. So I've been worried about this. Then the Cornell case comes out. So we're definitely going to see going forward more prohibited transaction claims. But I don't want to lose sight of the fact that what I'm really worried about going forward are the duty of loyalty claims, and plaintiffs really trying to ferret out all the potential conflicts of interest that exist in today's ERISA covered plans. Next slide, please. So I'm a visual thinker. If you will bear with me, please indulge me as I take you through my effort to understand and try to dissect the various ways that plaintiffs' lawyers may be looking for conflicts of interest in connection with America's ERISA covered plans. I guess you could say I have reinvented the wheel here because I call this the wheel of loyalty. Next slide. This whole slide is designed to show that conflicts of interest come in all shapes and sizes, and this is not a monolithic exercise of trying to ferret out and manage conflicts. They really require some careful dissection. So there's three basic ways that I think of conflicts affecting the plan and participant. The first, next slide, is what are the company's interests? The company that sponsors the plan. Does the company have some built-in conflicts of interest that are getting in the way of the plan? The next big category, next slide, is vendors. What interests do vendors have that may conflict with the interests of plan participants? And then the third one, next slide, are committee members. And this assumes that most of corporate America has set up a fiduciary committee to handle ERISA discharging ERISA fiduciary duties, and this applies to retirement plans and increasingly health and welfare plans. So I want to look at each of these categories in a little more depth to try to think through what are the various types of conflicts of interest that we in the defense world need to be thinking about. So first up, the company may have products that interact with the plan. So here you have the good old-fashioned affiliated funds. These are proprietary investment funds offered by a financial institution where the financial institution sets up its own 401k and then inserts its own affiliated funds into the plan's lineup. This has been going on for a long time. This is not new, but I will say there was a new case filed last week involving affiliated funds. So the focus in this regard continues. It's also pretty obvious that there's a potential for conflict there. The question is, how do you manage it? Another way that a company has potential conflicts is through the company's financial and non-financial goals, which might get tripped up with the focus on the best interests of the plan. This happens with ESOP transactions, where plaintiffs are challenging the amount paid for ESOP stock and they're alleging a duty of loyalty claim. We saw this in the high-profile ESG trial last year, where after a trial, a Texas District Court judge found that a company allowed its corporate focus on ESG goals to infect decisions being made on behalf of the plan participants. And there the judge was quite focused on the pecuniary interests of the plan and the participants. And the judge felt that the company's corporate preference for favoring ESG bled over into the way it administered its plan and led to a finding of liability. And that was a duty of loyalty claim. Actually, that company there successfully defended the prudence claims. It had followed prudent processes, but the court found that it violated its duty of loyalty by letting ESG goals get in the way. Again, I'm looking at this from the perspective of the plaintiff's lawyers. Where are the plaintiff's lawyers hunting for potential conflicts of interest? We're also seeing this in the wave of pension risk transfer lawsuits, which are being brought on the defined benefit side. Those cases allege that the plan sponsor wanted to de-risk its balance sheet and therefore entered into transactions for what were really the company's benefit in ways that didn't really benefit the participants. Again, this is how the plaintiff's lawyers look at it, not the way I look at it, but the way I look at things doesn't really matter. What I'm focused on and what I think fiduciaries should be focused on is where are the plaintiff's lawyers going next and what should we do to protect ourselves from that. And then as Nate said, the forfeiture cases, the wave of 50+ forfeiture cases, those are essentially duty of loyalty claims where the plaintiff says, you spent forfeiture assets to benefit the company rather than to benefit the participants. Again, this is part of my theory that there's this increasing focus by the plaintiff's bar, which is sophisticated, which is organized, which is well-funded. They're focusing on the fiduciary duty of loyalty. Next, moving over to the vendor piece of the world here. Next slide, you have the cross-pollination problem when a vendor is also a customer of the corporation. And you scratch my back, I'll scratch yours. The plaintiffs are on the lookout for these situations because the fiduciary's job is to make sure that the plan participant's back gets scratched, not that the company's back gets scratched. So we saw this in a high-profile case where a 401k plan committee allegedly favored the incumbent target date fund provider because that target date fund provider was also a huge customer of the company. So the allegation was that the fiduciary committee held on to underperforming target date funds for more than a decade because the provider of those funds was a huge customer of the company, and the fiduciary committee didn't want to upset that relationship. That is a big problem, led to a $69 million settlement, one of the larger ERISA class action settlements we've seen in a long time. Again, loyalty claims are high value claims, in my opinion. By the way, in that case, there was evidence that the fiduciary committee, when considering RFP candidates, kept a balance of trade ledger that listed how much corporate work, how much corporate revenue does the company get from each one of the potential vendors. And that was Exhibit A in the case that the plaintiffs brought, arguing that this fiduciary committee considered things other than the best interests of the participants. Next up in the vendor space, we have the situation where a vendor is also a significant stockholder or debt holder, and therefore the fiduciary committee treats them with kid gloves or pulls their punches. Other examples, moving on to the next one, there's a case against a bank that launched its own essentially PBM arm to try to reduce the cost of prescription drugs for its plan participants. Well, it turns out that that bank's investment banking clients in the healthcare space revolted and said they would pull their investment banking business, or it was implied, they would have allegedly implied they would pull their investment banking business from the bank if the bank entered this space and effectively reduced drug costs. The plaintiffs loved this, filed a complaint saying this shows that this bank was focused on its own corporate interests over the interests of participants. Next example with vendors is when a vendor was also a proxy activist, and the company, which was a huge consumer of fossil fuels, didn't want to draw the ire of this proxy activist, so exercised allegedly, or actually the court found after trial, that they exercised lax oversight over this vendor because they wanted to treat the vendor with kid gloves and stay on their good side. Switching over to the committee members, I mentioned tickets and networking and other things which might sound picky-uni and de minimis, and they might be, accepting the tickets to a ball game or having the vendor pick up the dinner tab. Seems relatively innocuous and is how business gets done in America, I suppose. But what upset the judge in this case, which was against a university, was that the person who accepted ball game tickets from the incumbent vendor during an RFP process didn't disclose this to his fellow committee members and didn't know if the committee had a rule against this or a rule requiring disclosure or prohibiting this. He testified that he thought his university had a conflict of interest policy, but he wasn't aware of whether his committee did. And the judge actually found this to be a prudence problem as well as a potential duty of loyalty problem, because if you don't have a process designed to ensure loyalty, that's a prudence problem. Other ways committee members get involved in potential conflicts is if they are too deferential to their day job supervisors in catering to what the company wants versus what they feel like they should be doing to protect the best interests of the plan. And then my last little nugget here involves the good old-fashioned employer stock cases, where committee members have inside information about the value of company stock held by a plan, and now there's a push and a pull between the insiders' duties to the corporation and their duties to the plan. So that is as my beginning way of starting to unravel the different kinds of potential conflicts of interest plan participants are going to look at, and I think we should make an effort in the rest of the year to unpack all this. So with that, I will take a deep breath and turn it over to Meredith to talk about some health and welfare litigation trends.
Thanks, Brian. So to close us out, I'm going to guess, as Brian said, through a few emerging trends in health and welfare litigation. Next slide, please. And so the first of these, you've probably heard of the 3 complaints that have been filed against Johnson & Johnson, Wells Fargo, and JP Morgan, challenging fees that their plans paid to their pharmacy benefit managers, or PBMs, and also challenging management of the plan's prescription drug benefits more generally. And these lawsuits have received a ton of attention, not only due to allegations that the plans are making their participants pay really high markups on prescription drugs, but also in large part because the types of ERISA claims alleged in these complaints have historically been limited to the retirement plan space. And so these complaints represent a major expansion of ERISA fee claims into the health plan space, into the prescription drug plan space. Next slide, please. So this chart breaks down the ERISA claims alleged in the various lawsuits and shows how they have evolved over time. You'll see that each of the 3 complaints alleges breaches of fiduciary duty claims for failing to select and monitor the plan's PBMs, failing to negotiate reasonable drug prices, failing to manage the plan formularies, and failure to monitor appointed plan fiduciaries. The complaints against Wells Fargo and JP Morgan additionally contain prohibited transaction claims with respect to administrative fees and compensation paid to plan PBMs. And the most recent complaint, which is against JP Morgan, is unique in that it also alleges a breach of the duty of loyalty. And as Brian was discussing, this is very on trend with the plaintiff's bar's recent focus on duty of loyalty claims and making it more difficult to dismiss those claims filed along with prohibited transaction claims. Next slide, please. So just quickly, this chart provides a snapshot of the status of each case. All of them are still ongoing. The ERISA claims against Johnson & Johnson and Wells Fargo were initially dismissed by their district courts, but plaintiffs have since refiled amended complaints, which are still being decided. Next slide, please. Sorry, there we go. And both of these complaints were dismissed for lack of standing, primarily because the district courts in each case held that plaintiffs failed to allege that they suffered individual harm as a result of the plan's alleged mismanagement with respect to its PBMs and prescription drug benefits. The courts weren't convinced by allegations that these allegedly high plan costs actually caused participants to pay higher premiums, higher out-of-pocket costs. They found that those claims are speculative. And these dismissals are consistent with the Supreme Court's kind of recent full decision and its progeny, which suggests it might be harder for plaintiffs in defined benefit plans and kind of analogous health plans to establish standing in these types of ERISA cases. And so the amended complaints that plaintiffs filed against Thompson & Johnson and Wells Fargo seem to be following similar strategies for addressing the standing pleading deficiencies that the court identified, and seem to be trying to take similar approaches to convince the courts that these high plan costs and administrative fees paid to PBMs cause plaintiffs to pay higher premiums and actually personally harm them. So one of these strategies that both complaints take is including in their amended complaints plaintiffs who participate in these health plans through COBRA. Because COBRA participants are going to be paying at least 100% of plan premiums without employer cost sharing, this may help them to allege a more direct tie between these high plan costs and high premiums. The Wells Fargo plaintiffs also retained an expert consultant to support these allegations that high prices equal high participant costs, and the Johnson & Johnson plaintiffs cite similar studies, concluding the same in their amended complaint. But generally, both of these amended complaints add a lot more detail about what plaintiffs actually paid and how they were harmed. So we'll see if these strategies help them to allege standing and get past the motion to dismiss stage this time around. Next slide, please. I think, as I mentioned, none of these cases have been decided on the merits yet, but as they're being decided, the similarities among the complaints provide us with a pretty good idea of what type of plan or company might be at risk of being targeted as a defendant in similar lawsuits going forward. So each of the plans targeted here is a Fortune 50 company that funds its plan through a trust that uses a traditional carve-out PBM with spread pricing. Plaintiffs allege that none of these plans recently conducted RFPs that included pass-through PBMs, which plaintiffs claim is something that a good, prudent health plan fiduciary should be doing. And interestingly, plaintiffs in each of these complaints, or in these cases, note that each of the companies has some business connection to the pharmaceutical or benefits consulting industry that suggests they should have known better than what plaintiffs are alleging they've done. So, for example, the Johnson & Johnson plaintiffs note that J&J has expertise in this area as a drug manufacturer. Wells Fargo, they call out, has a benefits consulting arm of its business. And they are noting that JP Morgan participates in an employer coalition that supposedly is providing its employer members with strategies for reducing spend on healthcare benefits, prescription drug benefits, that kind of thing. So based on these three complaints, a company seems to be an easier target for this type of litigation if it has some sort of inside knowledge of how PBMs or the drug pricing industry works and fails to apply that knowledge for the benefit of its participants, presumably due to its own business reasons. Next slide, please. And so it's clear that the plaintiff's attorneys in these cases are starting to leverage their decades of defined contribution plan litigation experience and apply what they've learned over the years to the health and welfare space. So to protect against these types of cases, it seems like it would be prudent for health plan fiduciaries to consider taking on some of those best practices that retirement plan fiduciaries have adopted over the years as a result of all of that litigation. And what these practices end up looking like for health plan fiduciaries will depend on how the cases play out. But the allegations and the complaints of what an allegedly good health plan fiduciary should or shouldn't be doing provides a general roadmap of actions that could be taken to possibly reduce litigation risk going forward. And so some of those allegations are listed here. It's things like conducting independent RFPs for PBMs, So confirming RFP vendor and service provider compensation, hiring third-party pharmacy consultants. But these cases really seem to be suggesting that health plan fiduciaries implement a more formal structure on the health plan side, similar to how they've been operating the retirement side fiduciary structures. So, for example, establishing a health and welfare plan fiduciary committee. Next slide, please. Another recent topic in the health space that's been getting a lot of attention are these recent settlements of tobacco surcharge lawsuits. And these are class actions challenging employer wellness programs that impose surcharges on tobacco users or that provide premium discounts for non-tobacco users. And these lawsuits have been filed over the past 2 years and generally contain a lot of the same allegations, namely that these tobacco surcharge programs violate HIPAA regulations that apply to health contingent wellness programs. And these are things like tobacco surcharge programs where participants are rewarded for satisfying a standard relating to a health factor. So like stopping smoking. The HIPAA wellness regulations require plan sponsors who impose these types of tobacco surcharges and premium discounts to offer a reasonable alternative method by which participants can qualify for the non-tobacco premium. They're required to provide the full annual reward to tobacco users who complete that reasonable alternative, and they're required to give notice of these reasonable alternative standards. And so all of these cases are alleging that plan sponsors failed to do this. And we wanted to flag these cases because the claims, some of these claims have settled for some pretty high amounts recently, the highest being the settlement of claims against Fast Pro Group for nearly $5 million. And so given these high settlements and the fact that these cases continue to be filed into 2025, employers who are imposing these types of wellness programs should ensure that they're being operated in compliance with HIPAA. Next slide, please. And the last topic that's also gotten a lot of attention recently are these lawsuits challenging health plan exclusions of GLP-1 drugs like Ozempic or Wegovy, where the drug is excluded when it's taken solely for weight loss purposes. So while these lawsuits don't involve ERISA claims per se, we wanted to flag these as ERISA adjacent, given the current focus on these drugs. And so there have been 2 lawsuits, Whitmore versus Cigna and Holland versus Elevance, where plaintiffs argued that excluding GLP-1 drugs for participants who are diagnosed with obesity, but not some other health condition like diabetes, discriminates on the basis of disability in violation of Section 1557 of the Affordable Care Act. And both of these lawsuits were recently dismissed by their respective district courts. The courts held that obesity by itself is not considered a disability for Affordable Care Act discrimination purposes. And so pending any appeals of these decisions and further developments in the litigation, these decisions should provide some comfort to employers who've decided not to cover GLP-1s for weight loss purposes. And that seems to be a pretty common decision right now. And that wraps up my slides, so I'll pass it back to Agnes.
All right, thank you, Meredith, and thank you all so much for sharing your expertise on this. We do have one question that has come up that I'm going to toss over to Nate. Are there any different thoughts about allowable uses of forfeiture funds if the balance in the forfeiture account consists of all vested uncashed checks?
So shout out to the questioner. That is a very good question and potentially forward-thinking one. The direct answer that I have is I don't have any different thoughts than the current forfeiture cases that are going through the courts, because the current cases haven't challenged the specific issue of uncashed checks. They've only focused to date on the employer unvested employer contributions. But it's forward thinking in the sense that the claims in these cases these class actions generally evolve, and we can expect them to evolve. And so I wouldn't give any different advice on this specific question other than to make sure that the practices are consistent with the plan, and also to follow any applicable guidance that the IRS or DOL has issued on that specific issue.
Okay, great. Thank you so much.
I have actually another. Do you mind if I just handle it in the interest of time? I just want to. There's another really good question that I just saw pop up about if the ERISA plaintiffs bar actively discusses strategy among themselves, or is it more informal, watch and see among the various plaintiffs' attorneys? So I don't know as a defense attorney, I don't know what goes on behind closed doors, but I can tell you that these attorneys are a lot of them are very sociable, and they do meet and they do talk. And so my assumption to that question is definitely yes. And I mean, that's played out by the fact that there's in a lot of lawsuits, a lot of plaintiffs firms will tackle suits together and appear in cases and handle different parts of the cases as kind of a divide and conquer. So that's another illustration of that.
And if I could add, Nate, under the prior administration, not this one, but under the prior administration, there was also an active discussion between certain leading plaintiffs' lawyers and the solicitor's office in the Department of Labor. And sometimes there was actually working in tandem without necessarily disclosing that they were working in tandem on investigations and the like. So, they are competitive with each other, those plaintiffs' lawyers. So they're not always working together unless they feel like they need to leverage other assets. But there certainly is some work between them and with the government under the prior administration. I don't know if there's a Department of Labor left under this administration, but under the prior administration, there certainly was a lot of cooperation.
All right, thanks to Nate and Tim for your insights. In the interest of time, we do have a few more great questions. We will follow up with you via email in order to answer those so that we can get everybody back to their day on time. But thank you all for joining us today. Within the next couple of days, you will receive a follow-up email with a recording of today's webinar and the presentation slides. If you have any additional questions that are not already in the chat that we weren't able to cover today, please reach out to your regular Thompson Hine lawyer. And if you're not a current client, please contact one of us to discuss available options that will address your needs. So thank you again for joining us and enjoy the rest of your day.